We are all living on this planet that is designated Earth. Whether you are living in Canada, Russia, United States, Great Britain, Germany, New Zealand, or the United Kingdom, there is one thing in common that we all share. All of us, no matter where we are located on this planet, are being governed, controlled, and restricted by law. It seems that law is universal and impacts every one of us, yet the majority of us do not even understand these laws that claim authority to govern us. Since the day we were born into existence, law came calling. Law came upon us, making demands of us. It seems that we had no choice but to be governed by this power, by the law, whatever it may be. Laws that state you must pay taxes, whether this be income tax, property tax, good and service taxes. Laws that control what you can and cannot do with your own property. Laws that force you to register your property. Laws that restrict and control your every action. So in truth, we have been born into bondage, born under a power designated law. Law grabs a hold of our lives and says, now you must conform. Now you must obey. However, law does not only demand obedience. Law is a hard taskmaster. If you fail to submit and obey the bondage of law, then law will seek to punish you and hurt you until, guess what? You conform to its will. There are laws that are created by government bodies, which are called or designated statutory laws, enactments, and regulations. These laws are created by legislators, government officers. They create these laws, brand new laws, and then claim you and I must obey them. There are laws that must be abided by if you are a Muslim. Then you believe that Sharia law is an obligation. If you believe in Judaism, then again, there are laws that must be followed. For instance, you must keep the Sabbath. These laws that flow from the religion create obligations. They are restrictive and controlling. I could go on and name hundreds and hundreds of religions, each one professing that there are certain laws, whether spiritual or physical, that must be followed. So, the regime of law, the power of law, is grasping at us from every aspect of our life, seeking to bring us under its controlling power. Let us back up here a little and look at another power that has come into our lives, that has come to us the day we were born into existence. We know that law came knocking on the door, claiming that we have obligations to it, and we must submit to it for the rest of our physical life. However, human rights and fundamental freedoms also came to us, not to restrict and control us, but to endow us with power, to be free from the constraints of law that seeks to place us unto subjection and servitude to it. Fundamental rights and freedoms. Human rights are rights that give every man and woman an opportunity to combat the controlling powers and restrictions of statutory law. Our fundamental rights and freedoms are the mechanism, the operation, the power we have at hand to stop law in its tracks. The problem has been that not very many individuals are aware of their rights, so they cannot use them to combat the restrictive nature and powers of the laws that are damaging them and taking energy from their life. Even though the government had the obligation to teach us about our fundamental rights and freedoms, they failed to do so. And they failed to do so in order to keep us trapped under the power of statutory laws. In order to keep us under subjection, they would not teach us the mechanism which directly combats their presupposed power over our lives. They would not teach us about are human rights and fundamental freedoms.
Human rights and fundamental freedoms primarily mean this to me, and we find the quote in the UDHR, the Human Rights Declaration, Article 1, and the preambles of the International Covenants. All human beings are born free, and the idea of free human beings. I am born free and have the capacity to remain free, a free human being. Law says that you were born a human being, but now we designate you a baby, child, teenager, adult. Law says we will designate you a class of being and claim that you owe us an obligation. Free human being becomes a taxpayer. Free human being becomes a driver. The free human being becomes a hunter. Free human being becomes a citizen. Law tries to take away your designation, your standing as a man or woman with full legal capacity, operating your human rights and freedoms, and make you into a class of being created by law, controlled by their law. A class of being is simply something in law that makes up and places obligations upon you. A class of being is created by law and given certain legal rights and duties of a human being for the purpose of legal reasoning and is treated more or less as a human being. Artificial person, an entity such as a corporation, created by law and given certain legal rights and duties of a human being. A being, real or imaginary, who for the purpose of legal reasoning is treated more or less as a human being. Law creates a class of being and then states you must obey what we tell you that you can and cannot do. Law creates the class of being designated driver and then controls the driver through the statutory power designated Highway Safety Act. Law creates the class of being designated taxpayer and then controls the taxpayer through the statutory power designated the Income Tax Act. Law creates the class of being fisherman and then controls the fisherman through the statutory power. Every class of being is controlled by enactments. Every class of being owes duties and obligations to the law of the enactment, and failure to perform the duty will result in punishment. Supreme Court of Canada, Thomson Newspaper Limited versus Canada. While individuals, as a rule, have full legal capacity by operation of law alone, artificial persons, classes of beings, are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. If you accept to be designated a class of being, whether that be a taxpayer, a driver, a hunter, a worker, real estate agent, etc., then the powers, rights, and duties you will have be forced upon you through the enactments through the government laws. The law will demand your subjection and obedience. When you look into the Civil Code of Quebec, Article 1, it states the following: every human being possesses juridical personality and has the full enjoyment of civil rights. Now, when you look to the definition of what a juridical personality is, it is actually an artificial person, which is an entity, such as a corporation, that is created by law. The human being is born into existence. The class of being, the artificial person, is created by law. And this class of person is given certain legal rights and duties of a human being. It is a being, real or imaginary, who for the purpose of legal reasoning is treated more or less as a human being. A government creation. Everyone, the human being, can take recognition as a person before the law. This is a right that a human being possesses. However, there is no obligation for that human being to enter into said recognition, to operate as a statutory creature governed by the statutory power. Why? Because, as a fundamental right, men and women are born free and can remain free. I am not created by law, but am born into existence. I do not possess certain rights and freedoms of a human being. I am a human being. While individuals, as a rule, have full legal capacity by operation of law alone, artificial persons, classes of beings, are creatures of the state and enjoy civil rights. So you're seeing that. A class of being enjoys civil rights and powers only upon the approval of statutory authorities, only upon the approval of enactments and regulations. Again, in the Quebec Civil Code, Article 1, every human being possesses juridical personality and has the full enjoyment of what? Civil rights. So statutory creatures, classes of beings, they exercise civil rights. Is the law stating that you have the obligation, the duty to use your civil rights? No, it says that you can enjoy them. This denotes the choice of the individual. It is a choice to use your civil rights or not. Civil rights are nothing more than rights, duties, and obligations placed upon the class of being through the enactment. If you operate as a taxpayer, then you are a class of being who is exercising civil rights. The law will claim that you owe duties and obligations, and part of that duty is to pay an income tax on the income you earned. In the law's eyes, you are a statutory creature exercising statutory rights and obligations. You and I, as free human beings, have the ability, the capacity to stand and exercise our fundamental rights. The statutory creature, the class of being, can never call upon these rights to use them. Men and women, as individuals, they can operate or stand under their full legal capacity. Within the definition of their full legal capacity exists their human rights, fundamental rights and freedoms, their common law rights. As N.A. versus Ryan stated, the Supreme Court judgment, that a trespass in common law nowadays must equal something an infringement or abridgment of a charter right. On the flip side to this, full legal capacity, you have the class of being, such as the driver or the taxpayer. This is a statutory creature, and this class of being is created by law. It's given certain rights and freedoms of a human being, and it is controlled by the enactments, by the statutory powers. And this class of being, who is controlled by enactments, are exercising civil rights, as we saw. They are endowed with civil rights. We, as individual men and women, exercise our fundamental rights and freedoms, our human rights. Let us look at what the Supreme Court says concerning classes of beings. Court Judgment, Supreme Court of Canada, SCC Thompson Newspaper Limited versus Canada. Everyone has the right to life, liberty, and security of the person. Serves to underline the human element involved. Only human beings can enjoy these rights. Everyone, then, must be read in the light of the rest of the section and defined to exclude corporations and other artificial entities, classes of beings, classes of persons, incapable of enjoying life, liberty, and security of the person, and include only human beings. We can see that artificial entities, class of beings, are incapable of exercising these rights. Remember, the law says that a class of being is created by law and given certain legal rights and duties of a human being. Well, we are seeing here some of the rights that were not produced for a statutory creature. If you accept the designation, operate from the position of a class of being, then you cannot call upon your human rights and freedoms. This is why it is very important that when you have interactions with any government body, you must make it extremely clear who it is that they are talking with. Are you a statutory creature, a class of being, created by law and controlled by the law, who owes obligations to them, or are you a man or a woman standing under their full legal capacity exercising their human rights and fundamental freedoms. Their default position is that they are dealing with a class of being who is controlled by law and owes the law obligations. The Supreme Court has made it clear that only men and women, human beings, can exercise the rights enumerated and brought forth in Section 7 of the Constitution Act. How come the article of law is not written to express this truth clearly and forthright? Constitution Act of Canada, 1982, Article 7. The subject and the player that we find indicated is everyone. Everyone has the right to life, liberty, and security of the person. It is only because we have done some research that we can understand this article of law is stating that men and women, human beings, have the right to life, liberty, and security of the person, and that these rights can be exercised only by men and women who operate not as a class of being. When you look into the Russian Constitution, you will find the following being brought forth in Article 17. In the Russian Federation, recognition and guarantees shall be provided for the rights and freedoms of man and citizen, according to the universally recognized principles and norms of international law, and according to the present Constitution. In Article 18 of the same Constitution, you find this: the rights and freedoms of man and citizen shall be directly operative. They determine the essence, meaning, and implementation of laws, the activities of the legislative and executive authorities, local self-government, and shall be ensured by what? By the administration of justice. So even in Russia, they understand that ultimately what a human being seeks after is the administration of justice. We are seeing in the Russian Constitution that human rights and freedoms are brought forth clearly and plainly. In fact, the Russian Constitution even states where this obligation to respect our human rights is flowing from. In Canada, we find no such distinction being brought forth, unless you know what you are looking for. The rights and freedoms of man are directly operative. That's what it states in the Russian Constitution. The rights and freedoms of a class of being, a statutory creature, the citizen, are directly operative. Do you consider yourself a Canadian citizen, a Russian citizen, an American citizen, a German citizen, etc.? Well, you should know that a citizen is a class of being, a statutory creature, and is controlled by the laws of the nation. As a statutory creature, the citizen does not have the same rights and freedoms which can be exercised by a man or woman. Looking into the Canadian Citizenship Enactment, Oath or Affirmation of Citizenship. I swear or affirm that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, Queen of Canada, her heirs and successors, and that I will faithfully observe the laws of Canada and fulfill my duties as a Canadian citizen. Allegiance is a citizen's obligation of fidelity and obedience to the government, or sovereign in our case, in return for the benefits of the protection of the state. Allegiance may be either an absolute and permanent obligation, or a qualified and temporary one. Citizen, a person who either by birth or naturalization is a member of a political community, owing allegiance to the community, and being entitled to enjoy what? All its civil rights and protections, a member of the civil state entitled to all its privileges. When you enter into recognition or take on the designation as a Canadian citizen, you have or are assumed to have sworn allegiance to Her Majesty, and that you have promised to obey the laws of Canada. You are operating as a subject and servant of Her Majesty, a class of being, a statutory creature, and are under obligation to obey her laws. Now again, that's why I say when you look into the enactments and regulations, you see that the first statement in these laws says, therefore Her Majesty, with the advice and consent of the Senate and House of Commons, enacts the following laws, because it's Her Majesty's laws. Oath, a solemn declaration, accompanied by a swearing to God or a revered person or thing, that one statement is true, or that one will be bound to a promise. The person making the oath implicitly invites punishment if the statement is untrue or the promise is broken. So law is binding you up under this oath of obedience, and is actually putting a hold upon your life, saying that you will be faithful and true, you give your allegiance to the Queen, and you promise to obey what she wants from your life. And they enforce this through the enactments, through changing your recognition before them. A citizen is a class of being who is no longer free. A citizen owes allegiance to the government or sovereign and can only exercise civil rights. Since the citizen is a statutory creature, it can never call upon or exercise fundamental human rights and freedoms. Only human beings can exercise their fundamental rights. But since the law changes your designation from full legal capacity, human being with human rights, unto a statutory creature, designated citizen, the ability to exercise your human rights becomes null and void. This subject or player, termed citizen, person, has lost the attribute to be free. It is being held in servitude through the operation of law that claims that the citizen owes allegiance to the government. The citizen was given certain legal rights and duties of a human being, but freedom was not one of them. The designation of citizen is a capacity that was created by law, and this designation was given only certain rights and freedoms of a human being.
For Her Majesty to read the speech from the throne. The Queen's private secretary will hand the speech to Her Majesty, who will read first in English.
Honourable members of the Senate, members of the House of Commons, I greet you as your Queen. Together, we constitute the Parliament of Canada. For the first time, the representatives of the people of Canada and their sovereign are here assembled on the occasion of the opening of Parliament. This is for all of us a moment to remember.
The Financial Administration Act, a federal enactment. Charges for rights and privileges. Article 19.1. The Governor and Council may, on the recommendation of the Treasury Board, by regulation, which means by law, by enactment, prescribe the fees or charges to be paid for a right or privilege conferred by or on behalf of Her Majesty in the right of Canada by means of a license, permit, or other authorization, by the persons or classes of persons on whom the right or privilege is confirmed. As a statutory creature, as a class of person that is a citizen, you have to pay for a right or privilege that Her Majesty will grant you, confer to you, allow you to operate, and she'll indicate that she's allowing you to operate these rights, these civil rights, by you being issued a license or a permit that you must carry around. So we see that we are taken from our full legal capacity as men and women, rendered a statutory creature that is designated a citizen under the Citizenship Enactment, and then the rights and freedoms that we are allowed to exercise must be conferred upon that class of being, must be given to that class of being, through a means of license and permit which must be paid for. So man, under his full legal capacity, operating his fundamental human rights and freedoms, is changed into the citizen, that statutory creature, the class of being. Now this statutory creature, the citizen, is exercising civil rights. No longer human rights and fundamental freedoms, but civil rights. And it even goes deeper than that. They have to pay for them. Pay for them. So the statutory creature, as a homeowner, property owner, under civil rights, you have to pay for permits, you have to pay for taxes, you have to respect their bylaws, etc. As a statutory creature, let's say a fisherman, for example, if you want to fish, you have to obtain a permit. And the law is stating that you're paying for these licenses and permits so that Her Majesty will confer or give you the right to take these actions. All within the context of civil law and civil rights. All because you're operating as a statutory creature. Taken directly from the Canada Heritage website. Her Majesty was the first of Canada's sovereigns to be proclaimed separately Queen of Canada. In 1953, a Canadian law, the Royal Style and Titles Act, formally conferred upon Elizabeth II the title Queen of Canada. Her Majesty was proclaimed in Canada by these words, "By the grace of God, of the United Kingdom, Canada and her other realms and territories, Queen, Head of the Commonwealth, Defender of the Faith." Queen Elizabeth II became the first monarch to be separately proclaimed Sovereign of Canada. The proclamation reaffirmed the new monarch's position as Queen of Canada, a role independent of that as Queen of the United Kingdom and the other Commonwealth realms. The Queen's role. As the living embodiment of the Crown, Her Majesty unites Canadians, gives a collective sense of belonging to our country, and anchors our sense of national identity and pride. New Canadians swear allegiance to the Queen. So do members of Parliament and the legislators, military and police officers. We do not swear allegiance to a piece of cloth, a document, or a political entity. Rather, we swear allegiance to a person who embodies all these as well as our collective values as a people. So on their own site, through their own membership, the Queen, Queen Elizabeth II, is a real person. And as you saw on the Heritage site, it says we're not swearing allegiance to a piece of cloth or to an office, but to a real person. Now we're under oath as the statutory creature to the Queen. And I'm simply talking right now in one aspect of this, as the statutory creature of citizen. I'm going to show more as the video goes on, but right now we're dealing with just the capacity and designation of citizen. As a statutory creature, you're under oath to her. Now, as a man, if you want to fish, for example, this is the easiest example I can use. If you want to fish, go catch a fish, fry it up, eat it, so your hunger goes away and you sustain your life. It's a natural right. It's a human right. Okay? You know what their laws declare in their enactments? It declares that the Queen, who is the Queen of Canada, she owns all the fish in the lakes and the rivers. And that you're not allowed to touch them or take them unless she confers a right upon you and gives you that right to go and take a fish. That's what their law says, that the Queen actually owns. Well, it doesn't legally say that she owns it. It says they're under the presumption of law, that those fish belong to the Queen. So when you go in there, if you're ever ticketed, you rebut that presumption. It can never stand in court. How can the Queen prove that God, if you believe in God, gave her all these fish in Canada, she's the steward of them? Or how can she say, if you were an atheist, that she has the right to lay claim upon all the fish? It doesn't stand, but it doesn't matter. That's how they created the law. So the presumption is that all those fish belong to Her Majesty, and you don't have the right, as a statutory creature, to touch even one of those fish, unless you pay for a permit. Then Her Majesty will confer upon you the right, and then you must abide by the enactment. The rights, obligations, and duties that you have as that fisherman now, because you applied for the permit, you're controlled, your civil rights, you as a statutory being, are being controlled by the statutory power now. So what just transpired here? Well, they took a natural right and they changed it. They changed it into a civil right, and they applied it upon a statutory creature. And they say, if you want to exercise this right from this standing of statutory creature, then you are going to be charged for this right. You have to pay for it. and then we will confer the right upon you civilly to exercise something that you possess naturally already.
This was not a typical Canada Day nor a typical royal visit. Both events come at a time when the country is preoccupied with questions about what its future holds.
Your Majesty's selfless commitment to the cause of Canada's unity and your deep personal understanding of both our promise and our problems explains why Your Majesty is held in such admiration and affection by so many millions of Canadians.
And while it's rare for the Queen to comment on such questions, she has in this tour and did so again today.
I am not just a fair-weather friend, and I am glad to be here at this sensitive time. I hope my presence may call to mind those many years of shared experience and raise new hopes for the future.
What many in the crowd wanted to hear.
I think she spoke very well, and as I said, it made us all proud to be Canadian on this day.
I enjoyed her speech so much. I thought it was very relevant for today with all the troubles we're having.
We love you! We love you! Hi there, this is Ryan calling from Toronto. I actually have two encounters to relate from two different generations. I know that my grandfather actually held the door at the Eaton store on College Street for the Queen Mum when she visited Toronto. Heck, I don't even know what that is or when that was. But yeah, and he was really proud of that story, and that was one of the high points of his life, I think. He liked telling that. And I remember when I was a kid, my mom said, "We're going to go see the Queen," when she came to Toronto, and I was probably about, 5 or 6 years old, and we went down and we stood outside the Royal York, and I think I saw the Queen for all of about 4 seconds trotting by on a horse. But let me tell you, my mom was excited about it, and her excitement kind of spread onto me, even though, I don't really remember much of it now. But those are my stories of the Queen, and that's about as close as the average person gets, I think.
Hi, my name is Gary, and I'm calling from Oakville, and my story occurred 40 years ago in Kingston. My husband and I were newlyweds. It was a boiling hot day. I was wearing nothing but my husband's short-sleeved cotton shirt over underwear, and I had bare feet because I'm short. The shirt fortunately reached almost to my knees. And at the last minute, we suddenly realized the Queen was about to pass by in her carriage. Well, we ran down the stairs, pushed our way out of the door, and we were at the very front of a couple of rows of people when the Queen looked over, and I swear I saw a very shocked look on her face because I looked as if I had nothing on but a shirt. I had no shoes, and I've never forgotten that.
My name is Cynthia Warren, and I live here in Toronto. When my son was about 3 years old, which is about 17 years ago, we were downtown on a cold Sunday afternoon near the St. Lawrence Market, and it was dead. There wasn't a soul on the streets. And perhaps this is not as close of an encounter as you would think, but in many ways it's probably closer. There was police with white gloves on everywhere, but no pedestrians, and we were walking up the sidewalk beside the market, and we couldn't figure out why it was so quiet, and we couldn't figure out why there were so many police around. And suddenly there came a motorcade. Police on motorcycles, an ambulance with flashing lights, a police car. I think there was even a small fire truck. And of course, the black rolls with the Queen and Prince Philip in it. My son was entranced with the parade of vehicles and their flashing lights. And he was waving for all his might at all of these vehicles going by at a sedate pace. Prince Philip saw him, as we were the only people on the street, and pointed him out to the Queen, and they both began to laugh. They were only about 15 feet from us. And they laughed because they'd been upstaged by an ambulance in the eyes of a 3-year-old boy. And after that, they always seemed so much more human to me. Thank you.
Canada. You, along with most individuals probably, think that when you say the term Canada, you are referring to a country, a landmass, to which you are a part of because you live on the landmass. This, however, could not be further from the truth. The law declares that the term Canada, the designation Canada, refers to a corporate body, a company. Supreme Court of Canada, authority of Parliament in relation to the Upper House. Further, although Section 91.1 of the Constitution Act of Canada 1867 gave the Queen the power, with the advice and consent of the Senate and the House of Commons, to alter the Constitution of Canada, except in certain expressly designated areas, it does not confer a power to amend the BNA Act. The word Canada in Section 91.1 does not refer to Canada as a geographical unit, but refers to the juristic federal unit. When you look into the dictionary to find out what a juristic person is or a juristic federal unit is, it says see artificial person under person. Then you look at it and it says it's an entity such as a corporation created by law and given certain legal rights and duties of a human being. A being, real or imaginary, who for the purpose of legal reasoning is treated more or less as a human being. The Canada being spoken about and brought forth in the Constitution Act of 1867 is a corporate body, and we, as inhabitants, are being incorporated into this corporation. I know this sounds ridiculous, but this is exactly what the law is declaring. We think, when we see the Canadian flag, that it represents Canada and wonderful liberty. It doesn't. The flag of Canada is the corporate logo of Canada. Just like McDonald's has a corporate logo, or Kentucky Fried Chicken has a corporate logo, well, Canada, as a corporation, has a logo, and it's the Canadian flag. Since we can clearly see that Canada is a corporate body, then we should be able to find the subsequent evidence of this fact when we look into Canada and its controlling powers when they are mentioned within domestic law. So we look into the Constitution Act, Article 9 of 1867, and it says the executive government and authority of and over Canada is hereby declared to continue and be vested in the Queen. It goes on to state in the Constitution Act of 1867, the provisions of this act referring to the Governor General extend and apply to the Governor General for the time being of Canada, or other, the Chief Executive Officer or Administrator for the time being, carrying on the Government of Canada on behalf and in the name of the Queen, by whatever title he is designated. So we learn very clearly that the executive government, the authority and power over Canada, is declared to continue to be vested in the Queen. And we understand that the Queen is not some type of fictional character. She's a real person, a real individual. Now, the Governor General is exercising powers on behalf of the Queen, on behalf of the Government of Canada, but he is in subjection to the Queen, even though he's the Chief Executive Officer of this corporate body. Black Laws, edition number 7. Black Laws is simply a legal dictionary that defines words and terms for us. Chief Executive Officer, a corporation's highest ranking administrator who manages the firm day by day and reports to the board of directors. Canada is a company in law, and the executive powers belong to the Queen. We are forced to promise to obey this executive power through the oath of allegiance. Not only is Canada a corporate body in law, wherever you are presently living is also considered a corporate body, and you have been incorporated into the company. When you look at the law, the statutory powers, you find the following. Ontario Municipal Act. Municipality means a geographic area whose inhabitants are incorporated. Body corporate. The inhabitants of every municipality are incorporated as a body corporate. City of Toronto Act. The City of Toronto is hereby continued as a body corporate that is composed of its inhabitants of its geographical area. Municipality means a geographic area whose inhabitants are incorporated. So when you use the term Toronto, you are referring to a corporate body. And this corporate body, they have incorporated you into their body. You are operating from the capacity, from the designation of a statutory creature, which is an officer of the corporate body. And this is why they seek to regulate you and control you with their bylaws. This is the link that they are using. They are claiming that you are a statutory creature who has been incorporated into the corporation. Now you are an officer and you must obey the corporate body laws. City of Vancouver, Charter of Vancouver, Corporation and Boundaries. The inhabitants of the area, the boundaries of which are described in this section, shall continue to be a corporation and a municipality with the name of the City of Vancouver. New Brunswick, Municipal Enactment. The inhabitants of the cities and towns in existence on January 1st, 1967, continue to be bodies corporate. The inhabitants of a municipality created under this Act are a body corporate, named under the name prescribed for it under this Act. Nova Scotia Municipal Act. Every municipality incorporated at the date of this Act comes into force is subject to this Act. The inhabitants of the County of Cape Breton are and continue to be a body corporate. The inhabitants of County of Queens are and continue to be a body corporate. City of Winnipeg Charter. City continued. Article 8. The City of Winnipeg, as constituted immediately before the coming into force of this Act, is continued as a body corporate. We are being forced to play the role and enter into recognition as a class of person, officer, before the law, which is contrary to our natural rights and freedoms. Since we are being forced into recognition as a class of being, we are automatically prevented from exercising our human rights and freedoms, since only human beings can exercise these rights, yet the law has designated us, a statutory creature. We find the same operation of law in the Criminal Code of Canada. We can see that the inhabitants are incorporated. Incorporated into what? Well, the body corporate. Municipality, definition under the Criminal Code of Canada, includes the corporation of a city, town, village, county, township, parish, or other territorial or local division of a province, the inhabitants of which are incorporated, or are entitled to hold property collectively for a public purpose. Law is trying to make us all statutory creatures, classes of beings who are controlled by enactments and regulations, exercising civil rights. This is what the law deems us and wants us to stand under. Canada, Toronto, Winnipeg, Vancouver. When you state these designations in law, you are talking about a corporate body. Now you can also state wherever it is that you live, who is watching this video, wherever you live, municipality, city, when you state that name, you're stating a corporate body. That's what the law declares. And these places are considered statutory creatures, class of being, created by law. Corporate body of Canada, created by law. Executive powers belong to the Queen. They said we swore allegiance to this power. Toronto is a corporate body, statutory creature, created by law. You and me, according to their laws, have been incorporated into the company. The inhabitants of the area are incorporated into the corporate body. By doing that, you become a statutory creature. Exercising what? Civil rights. Having obligations to what? The enactments and regulations. Having duties to what? The bylaws. They incorporate you into the companies. They consider you an officer. And now you have to obey the laws and regulations that are brought forth. This is a true deception we are living in. Every aspect of our life, we are transformed by the power of law from a free human being into a statutory creature. a class of being who now owes obligations and duties to the executive powers of the corporate body through these enactments. Human rights and freedoms, fundamental rights and freedoms, exist apart from enactments and regulations. These natural rights are actually fundamental law. Black laws, fundamental law, the organic law that establishes the governing principles of a nation or state, constitutional law, also termed organic law, see natural law. We see that fundamental law is the organic law which brings forth and establishes the governing principles of a nation. It is the supreme law of the land, and it is the controlling mechanism for the nation and the government body. These natural human rights are the principles which govern a nation. They are to find their expression in the Constitution. Fundamental right, according to black laws, a right derived from natural or fundamental law. 2. Constitutional law. So here we're seeing that fundamental law and fundamental rights have to be found within constitutional law of the nations. We are seeing that fundamental law, which are natural rights, are the primary rights that govern a nation. And these laws find their expression in the constitutional process or constitutional law. Natural law, human rights, inalienable, absolute right. They can never be removed, and Canada must respect these rights and these laws. Natural law, human rights, it's the fundamental law of a nation, the primary law of a nation, and it is expressed through the Constitution Acts. Organic law, the bodies of law, as in the Constitution, that define and establish government, fundamental law. The international covenants, as we have seen, are an expression of natural rights. These fundamental human rights create an obligation upon Canada to respect them and allow their expression within their territory. International Covenant on Civil and Political Rights, Article 2.2. Were not already provided for by existing legislative or other measures. Each state party to the present covenant undertakes to take the necessary steps, now watch, in accordance with its constitutional process and with the provisions of the present covenant, to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So the rights that are recognized in the covenant, our countries had to adopt laws and had to contain these rights within its constitutional process. Well, why would the International Covenant on Civil and Political Rights state that the rights that are being expressed within the covenant have to be placed within the constitution of the state party, of the country, if we understand that the Constitution expresses fundamental rights, expresses fundamental law? Because what it was trying to say and bring forth is that these rights and freedoms, these human rights and freedoms, are fundamental law. And they are the laws that are to govern nations as of now. Every nation that became a signatory to these covenants came under the obligation. Now you are under the obligation to respect these rights. It is fundamental law within your nation. Therefore, it must be expressed within the constitutional process of your nation. Why? Because it's fundamental law. And that's where we find fundamental law. Primary principles of law is within the constitutions. That's why when you look into the Constitution of Canada itself, it states that the Constitution of Canada is what? It's the supreme law of Canada. Why? Because it's expressing fundamental law, natural law. This is why it is the supreme law of Canada. And by default, it is expressing our fundamental human rights and freedoms that are recognized within the covenant. All these fundamental human rights had to be expressed within the Constitution Act, or other measures had to be created to allow the expression of these rights. Otherwise, Canada and the other countries would be in default of their obligations. Whatever fundamental rights and freedoms that are present in the covenants had to be expressed in the Constitution of the State Party Canada. And more specifically, our positive rights, our natural rights that apply for men and women and not statutory creatures, they were contained in our Constitution Act of Canada. The covenants are the controlling mechanism concerning Canadian law and the expression of our fundamental rights. Canada cannot just make up laws. They must transfer and fulfill the laws that are present in the covenants into domestic law. This new Constitution Act was to bring forth, was to express, was to create a mechanism to give effect to the rights that were recognized in the covenants. There were rights and freedoms that are recognized in the covenants, which Canada had to bring forth through the Constitution Act or other measures. This was the obligation upon them. Fundamental law is the supreme law of a nation. We understand that the supreme law of a nation, fundamental law, it must express, it must contain organic law, which are natural laws, natural rights. Now in 2017, natural law or natural rights has found their expression through our human rights and fundamental freedoms. So it must be expressed within the fundamental law of a nation. And the fundamental law of a nation, the primary laws of our countries, are the constitutions. The constitutions are under obligation to express human rights and fundamental freedoms. The international covenants, which places this obligation upon the nations, are an expression of a dual capacity. On one hand, we see there are rights and freedoms contained within it for the expression of statutory creatures, such as the citizen. And then on the other hand, there are rights and freedoms that are never to be limited or abridged, that are there and are in place for men and women to stand upon. Now, the latter, the rights of the men and women, these are the rights that must find their expression within the fundamental law of the nation. Not all of the rights of the International Covenant is under the obligation to find its expression in the fundamental law. Only the parts of the covenant that bring forth the natural law, which we understand is human rights and fundamental freedoms. But that's the obligation. Because why? Because natural law, our human rights and fundamental freedoms, it is the expression of fundamental law. And that has to be included within the Constitution. That's what the International Covenant places the obligation upon the state parties to do. Not to take all of the covenants and implement them within the Constitution. Just the ones that express our positive rights, our natural rights, our human rights and fundamental freedoms. Therefore, the rest of them within the covenant that apply to statutory creatures, they're brought about through statutory law. And unless there's been an enactment that's been created to bring forth the right, the duty, the obligation, whatever it may be upon the statutory creature, then the obligation is not placed upon Canada. But when you're talking about fundamental law, natural law, human rights, there's no room to move there. International Covenant states it clearly. It must be expressed within the Constitution. Okay, we can wiggle out. Well, it doesn't directly say all of them. No, exactly. But what does the Constitution represent in your country? According to your Constitution. Here in Canada, it says it's the supreme law of Canada. It's above all enactments. It's above all regulations. That's what the Constitution is. So it's declaring it is indeed the fundamental law of the country. It's the supreme law of the nation. Okay, great. If it's the supreme law of the nation, if it's the fundamental law of the nation, then the obligation rests upon the executive powers of Canada to express natural law, human rights and fundamental freedoms. That's why the Supreme Court, R versus Wagner, the judge clearly said the writers of our Constitution clearly understood their obligations. Because positive rights, our natural rights, our fundamental rights and freedoms have been contained and expressed in all of the Constitution? No, in certain articles of the Constitution. They were aware of their obligation as a foundational document to this corporate body, which we call Canada, that they had to include these laws within the Constitution, and they did. The Constitution Act of Canada, 1982, Article 7. Everyone has the right to life, liberty, and security of the person. R. versus Wagner, Court Judgment. The rule of law. The rule of law not only finds itself in the preamble to the Charter of Rights, its spirit is manifested throughout the document, from the restrictions on the state's powers, finally at the developing fringes of the new natural law, which goes by the name human rights. So we are seeing here that natural law is being expressed through human rights and fundamental freedoms. Now, those unwritten principles tend to be largely replicated in the text of the Constitution, with Section 7 of Canada's Charter of Rights striking me as a prime example. He didn't say only example, he said prime example. Our written Constitution reflects many, many influences, including the drafter's awareness of natural law. So if Section 7 is expressing natural law, and natural law is our human rights and fundamental freedoms in 2017, and since the Constitution is the foundational law of the nation, it's not a big surprise that we find our natural rights and our fundamental human rights contained and protected within certain articles of the Constitution Act of Canada. The obligation is there. It's supreme law.
6 weeks ago, the House of Commons in Canada passed the Bill of Rights. This was presumably to help to safeguard our rights against an encroaching state and against the encroaching complexities of our society. But rather than prejudge the issue, we have the man who can tell us about that, and I'm going to address my first question directly to him. Mr. Fulton, what was the thinking behind the Bill of Rights? Why was it passed at this last session of Parliament?
Well, there are a number of reasons I could give, but I'll try and give you just 2 or 3 of the main ones. The first is one that you have yourself mentioned, and that is the increasing complexity of government and the fact that government now enters into the private life and affairs affecting the private welfare of individuals in ways in which it never used to do, say, 50 years or more ago. So it seemed to us important then to have legislation on our statute books outlining the rights and freedoms of an individual against which a government could not encroach.
Are these new, or is this merely a formalization of what has already existed?
No, we haven't pretended that we're creating a vast number of new rights. We're reducing to legislative and concrete form, thus giving them that much more protection, rights which we have always taken for granted in Canada. That leads me into the second reason, and that is that to a great extent, if not completely, we in Canada, while possessing and enjoying these rights and freedoms, have possessed them by what I might call the accident of inheritance. No one is prouder than I am of the fact that we do inherit the British constitutional system and the principles of the British common law. But there are many thousands, if not millions, of Canadians now who have come from countries where these principles are not necessarily known, so that for that reason it seemed desirable to have our own declaration of rights in order that they might form part of Canadian legislation rather than merely being enjoyed by the accident of inheritance. We should declare to the world that we were prepared to accept that administrative inconvenience because we set at the pinnacle the rights and freedoms which we have now written into our Canadian statute as a Canadian Bill of Rights. That was the sort of reasoning behind our decision and the Prime Minister's decision to introduce a Bill of Rights as a Canadian statute.
Well, Mr. Riddell, you have in the United States a written constitution, a Bill of Rights. Is this would you say these are some of the reasons why you have one too, or is this not applicable?
No, I think it's not applicable at all because ours was written 170 years ago in the face of a war, or in the memory of a war which I won't refer to here with our good friends. But if I may, I'd like to say 3 things about this new Canadian Bill of Rights. First, it is very much like our constitutional Bill of Rights in most of the things which it purports to protect against. There are minor things which we have in our Bill of Rights and you don't. There are minor things which you have and we don't. But essentially, though ours is in the Constitution or the Basic Charter, and yours is legislative, which I gather means it may be repealed at any time as ours cannot, their purpose is the same, and their purpose is, of course, laudable. Second, I'd like to say that the Bill of Rights is just as worthless as ours is. It is worthless because it is nothing but words on paper until men put it into action. I've marked a few phrases in it. There is a prohibition against arbitrary detention, imprisonment, exile, etc. Who is to decide what is arbitrary? There is a requirement that someone arrested must be informed promptly of the reason. Who's going to say what is promptly? There is a requirement that you can't deprive a person of a right to a fair hearing, and what does fair mean? In accordance with the principles of fundamental justice, and who is to say what fundamental justice is? Is it the cop on the corner, or is it probably the judges? Our late Chief Justice Hughes once said, "We are under a Constitution, but the Constitution is what the judges say it is." For that reason, I say, essentially, the words of your Bill of Rights, like the words of our Bill of Rights, are worthless without men who will put it into effect in a decent way. But I would say, third, that it's a very hopeful sign. I'm glad you enacted it for this rather practical, I think, reason. When you do get a liberal judge faced with a complaint under either your or our Bill of Rights, he has in these words a lawyer's excuse to act in a liberal way, something which he might not have had if you had not written this into law. And that, to me, is the real value of both your and our Bills of Rights.
Well, you pointed out some of the shortcomings in your view. Is this perhaps, Mr. McGarry, why the British do not have a written Bill of Rights?
Well, we have a Bill of Rights. We had one in 1689. I think ours is the oldest Bill of Rights. But what really matters, of course, is the individual acts of Parliament that are passed each year by each of the Parliaments. Do you have acts of Parliament that have written into them a real protection for the subject? That's what really matters. And general statements in a Bill of Rights are good as pointing the way to the sort of things that ought to be enforced by the law. But what really matters is the individual acts of Parliament, and also, I should have thought, what the courts actually do. I'd agree with Rodell entirely that this is good as giving an excuse for a judge who wants to do justice in a difficult case. But one must look at the other side of the penny also. All acts of Parliament passed in Canada up to date have now got to be scrutinised in the light of this Bill of Rights. The arguments that can be thought up by any ingenious lawyer as to how some existing act of Parliament conflicts with this Bill of Rights are almost innumerable. And just how much extra litigation this is going to result in, I, as an Englishman, wouldn't like to say, sitting here in Canada.
May I ask
well, Mr. Fulton wanted to get his oar in here.
There are two things that should be said. I was impressed and, of course, aroused by Professor Rodell's comment on our bill being as worthless as the American Bill of Rights. I would think that the more correct way of stating it is that our bill is as worthy as the American Bill of Rights, and the American Bill of Rights has, I think, indisputably been used and been the foundation of a good many of the heads of the liberty of the subject in the United States. Secondly, I couldn't accept, without challenge, Mr. McGarry's statement that what is going to happen depends entirely upon the legislation introduced, the subsequent legislation introduced in Parliament, and the extent to which safeguards are written there, because the Canadian Bill of Rights, by express provision, lays down to the courts a rule of interpretation which they will apply in dealing with statutes previously enacted and with statutes subsequently enacted, unless those statutes expressly provide that they shall have effect notwithstanding the Bill of Rights.
We're looking at the Canadian Bill of Rights, which was given royal assent in 1960. It says, "This is an act for the recognition and protection of human rights and fundamental freedoms." We first must note that this is a statutory power. It's an enactment. It's not a constitution. Therefore, it doesn't represent the foundational law, the organic law, or the ground law of the nation. It is simply a statutory power bringing forth rights and freedoms in order to try and protect human rights and fundamental freedoms. The preamble states, "The Parliament of Canada, affirming that the Canadian nation is founded upon the principles that acknowledge the supremacy of God, the dignity and worth of the human person,
and the position of the family in society of free men and free institutions, affirming also that men and institutions remain free only when freedom is founded upon respect for moral and spiritual values and the rule of law. So you're seeing there's three different qualifications they brought forth there. And being desirous of enshrining these principles and the human rights and fundamental freedoms derived from them in a Bill of Rights, a statutory power, not foundational law, which shall reflect the respect of Parliament for its constitutional authority, and which shall ensure the protection of these rights and freedoms in Canada. Now, in Canada, what do you think they're referring to? Again, the corporate body. Therefore, Her Majesty, the executive powers of Canada, by and with the advice and consent of the Senate and House of the Commons of Canada, enacts as follows. Part 1. The Bill of Rights. Recognition and Declaration of Rights and Freedoms. It is hereby recognized and declared that in Canada there have existed and should continue to exist without discrimination by reason of race, national origin, color, religion, or sex, the following human rights and fundamental freedoms, namely, the right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except by due process of law. Now, this is a similar article of law as we find in the Constitution Act of Canada, Article 7. Now, the Constitution Act is the ground law, it is the foundational law of the nation, and therefore our human rights and fundamental freedoms have been expressed within it. Now, in Article 7, it says everyone has the right to life, liberty, and security of the person. So it's basically the same thing. The Bill of Rights says the individual. We know that the individual is only referring to the human being, the man or the woman, because it's only a man or a woman who can express these human rights and fundamental freedoms. So this says we have the right to life, liberty, and security of the person in the Constitution, but they don't add the enjoyment of property within the Constitution, although they have it in the Bill of Rights. So you see the difference in one. The statutory power is saying that you have the right to the enjoyment of property, but the foundational law of Canada isn't enumerating it or listing it directly. But it's still contained within the Constitution, as we will see. So the Bill of Rights, Article 2. Every law of Canada unless it is expressly declared by an Act of Parliament of Canada that it shall operate notwithstanding the Canadian Bill of Rights, be so construed and applied as not to abrogate, abridge, or infringe, or to authorize the abrogation, abridgment, or infringement of any of the rights or freedoms herein recognized and declared. So what this is saying is that no statutory power, no enactment or regulation has the right to limit or abridge your rights that you find here in Article 1. So you as a human being, as a man or a woman, you have the right to life, liberty, security of the person, and the enjoyment of property. And it's specifically declaring that you're not allowed to limit or abridge these rights or freedoms unless within the enactment itself there's a notwithstanding clause, which they don't use. So it doesn't matter, but that's still the fact that they're saying. So you have these rights according to the Bill of Rights, and they're not to be limited or abridged. Now you look at the Constitution Act of Canada, and it states a similar thing in Article 52. The Constitution of Canada is the supreme law of Canada, foundational law. And any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. So the operation of law is saying that the supreme law of Canada is the Constitution. And if there's an enactment or regulation that goes against your rights as enumerated in the Constitution, then that enactment, that statutory power, is of no force or effect against you. And that's exactly what it's saying in the Bill of Rights here. It's saying that you have these rights, and they do not authorize the Parliament to create any enactment or regulation that limits or abridges your fundamental rights and freedoms. So on one hand, we have a statutory power that's bringing forth fundamental rights and freedoms, and then since 1982, it's now contained within the Constitution Act of Canada, within the foundational law of Canada. In the Bill of Rights, Article 5, it says nothing in Part 1 of the Bill of Rights shall be construed to abrogate or abridge any human right or fundamental freedom not enumerated therein that may have existed in Canada at the commencement of this Act. So they're saying we recognize and we declared some of the rights and freedoms of the human being, but just because you don't find them mentioned, if you are aware of other rights and freedoms of a human being, of a man and woman, and they're not mentioned in the Bill of Rights, it doesn't mean that we are saying that they don't exist here in Canada. And again, this agrees with the Constitution Act of Canada 1982, Article 26, where it says the guarantee in this charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. The Bill of Rights was a statutory power that was trying to express our fundamental human rights and freedoms, but it didn't have the kick or the power behind it as the Constitution Act does when it comes to enforcing our rights and freedoms. The international covenants demand, place the obligation upon Canada to respect individual rights and freedoms, human rights and freedoms. Individual, as a human being, as one single man or woman, Canada must respect and ensure these rights for you. Individual, as an entity, as the officer of Canada, as a statutory creature, as a Canadian citizen, Canada must respect these rights for you. When we look into the International Covenant on Civil and Political Rights, Article 25, we find this mentioned. Every citizen, so you notice the subject and player, it's not an everyone, it's not the human being, it's a citizen. It's a statutory creature created by law who's under oath and allegiance to a political party or to a sovereign. Here in Canada, it's to Her Majesty. Every citizen shall have the right and the opportunity to vote and be elected at genuine periodic elections. Now again, this right that is brought forth in the International Covenant, Canada is obligated to transfer it into domestic law. It can do it through the Constitution Act or through a statutory power, an enactment. And the obligation upon Canada and other countries to fulfill this comes through in Article 2.2 of the International Covenant. Were not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So here the covenant in Article 25 is recognizing the right of the citizen, the statutory creature, to vote. And now it's saying, you, state party, you have to transfer it into domestic law, whether through the constitutional process or through another provision. Now we know voting, the right to vote, it's not a foundational law. It really isn't, because it's given to a statutory creature, not to a human being. You can be resident in Canada, an immigrant, and you're not allowed to vote until you become a Canadian citizen. That right attaches itself only to the statutory creature of citizen. Now, when we look into the Constitution Act of Canada, Article 3, it says every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly, and to be qualified for the membership therein. So we see the International Covenant bringing forth the right for the statutory creature to be able to vote, and then we see it being fulfilled in domestic law through the Constitution Act. Right to vote. International Covenant brings forth this right. Right to vote is for the citizen only, that statutory creature. Respect and ensure the individual's right. Constitution brings forth this right, fulfills their obligation towards what the covenant is asking them to do. We can see that the primary controlling mechanism is the international covenants. The rights and freedoms that are listed in the covenants must find their way into the Constitution Act when you're talking about human rights and the rights of men and women. They can add the rights of the statutory creature within the foundational law of the nation, but they're not obligated to do that. They can use enactments and regulations to bring forth the statutory creature's rights. But when it comes down to expressing our rights as men and women, it must be included within the foundational law of the nation. The covenant brings forth a certain right, and Canada as a state party must express this right. In DeVito versus Canada, Supreme Court judgment in 2013. Now be wary of people who come to you and say, look at my judgment, what it's saying. It's from 2001, or 1999, or 1976, or 1996, or whatever, because there are a few people around there that are floating old judgments out, and they're relying on that. The way jurisprudence works is the newer the jurisprudence, it overrides the older ones. And yes, if you're looking back 25, 30 years ago, not very many individuals were aware of their human rights and freedoms. But over the past 5 or 10 years, there has been a very big growth and sort of a insurgents of people seeking after their rights against the government. Because as the government encroached more and more upon their lives through enactments and regulations, people began to feel the effects and began to wonder, is there something I can do? What's going on? And more individuals went before the courts seeking their rights. And therefore the courts were being brought to the point where they had no choice but to deal with human rights and fundamental freedoms. So you're looking at a case from 2013, and it says Canada's international obligations are relevant principles of international law, are also instructive in defining the right. The content of Canada's international human rights obligation is, in my opinion, in my view, an important indic of the meaning of the full benefit of the Charter's protection. I believe that the Charter should generally be presumed to provide protection at least as great as that afforded by similar provisions in international human rights documents. So here the judge is declaring the Charter's job, or the Charter's responsibility, is to provide protection to us individuals, concerning our human rights and fundamental freedoms. The rights that are expressed in the international covenants, the rights that are brought forth and are protected there, the Charter should offer us the exact same protection. Association versus British Columbia confirmed that the Charter should be presumed to provide at least as great a level of protection as is found in the international human rights documents that Canada has ratified. Looking into the International Covenant on Civil and Political Rights, Article 25, we find that the citizen, the statutory creature, has been given a right, and this is the right to vote. Now, the obligation to transfer this right into domestic law comes out through the International Covenant in Article 2.2. So what does Canada do? Well, it takes the obligation in Article 25, and it transfers the right into Article 3 of the Constitution Act of Canada. Now, the rights of the statutory creature, the citizen, has to be expressed. It has to be brought forth, because the International Covenant says so. Now, the rights for men and women under their full legal capacity, this also must be brought forth. And when you're dealing with natural law, with human rights, here are a few of them. Article 3, Article 8, and Article 16 of the Covenants express positive rights, natural rights, human rights, and fundamental freedoms, not rights that attach to statutory creatures, to artificial persons, to classes of beings. The Supreme Court of Canada has declared that the Constitution Act of Canada 1982, the Charter of Rights and Freedoms, should afford to us as individuals, men and women, as much protection as the International Covenant allows or brings forth or is expressed in that covenant. Now, when we look in the International Covenant on Civil and Political Rights, Article 8, it states that no one shall be held in slavery and no one shall be held in servitude. Okay, well, why is there a statutory power, an enactment, that is placing individuals on this territory into servitude through an oath and through a pledge of allegiance? Now, some people will say, well, it's a statutory power, it's a class of being, so it doesn't really matter. Absolutely, 100%. If and when you choose to operate from that designation and choose to stand under that designation, then you willfully give up your right, your human right, not to be held in servitude. You willfully give it up. So you can go to a local courthouse and watch new immigrants come into the country who have been resident, that word, in Canada for a while, and now their citizenship has been accepted, and they're going to take the oath of allegiance. Well, they just took the oath of allegiance, and what they did is they placed themselves into servitude. However, the International Covenant says that no one shall be held in servitude. So if I choose not to take recognition or designation as that citizen, not to be held in servitude to Her Majesty, not to owe Her Majesty allegiance, the State Party Canada has the obligation to respect that choice and protect it. And it comes out in the Constitution Act of 1982, Article 7, where it says everyone, and we know that everyone refers strictly to the human being, to a man or a woman. A statutory creature cannot invoke this right, but the man or the woman has the right to life and to liberty. and liberty is the opposite of servitude. So if you stand under your full legal capacity as a man or a woman and you say that I'm exercising my right to liberty that is protected within the Constitution Act of Canada, the foundational law, the ground law of this country, that allows me to say I'm not giving up my right not to be held in servitude in order to go into allegiance to Her Majesty, who is the executive ruling power of the corporate body. Remember, the Canadian Charter of Rights and Decisions Digest, Justice Canada, Section 7. It was intended to confer protection on a singularly human level. A plain common sense reading of the phrase, everyone has the right to life, liberty, and security of the person, and we see that same phrase in the Bill of Rights, Article 1, serves to underline the human element involved. Only human beings can enjoy these rights. Everyone then must be read in the light of the rest of this section and defined to exclude corporations and other artificial entities, statutory creatures, class of persons, class of beings, incapable of enjoying life, liberty, or security of the person, and include only the human being. So going back up here to the Canadian Citizenship Act. So we have a man that's standing, let's say he comes from any country, China. He comes from China, he wants to immigrate to Canada. He's been resident in Canada for a while, and now he's standing there with his fundamental rights and freedoms. And his fundamental right and freedom says that no one, sir, can hold you in servitude. There's no one that should have the right to place you under subjection, that should demand their allegiance from you, that should say that you owe them an oath, and that unless you willfully do it. As a citizen, the statutory creature was not given the right not to be held in servitude. In fact, it was given the right to be held in servitude, as you saw before. As a citizen, as an officer of the corporate body of Canada, you have to pledge your allegiance to Her Majesty, and then you have to pay for permits and licenses in order to have Her Majesty confer a right upon you that you may exercise. The statutory creature can't exercise the right. You're standing there at that time as a resident of Canada. You now take the oath. You're no longer resident. You're a citizen. As a citizen, you're under oath, under true allegiance to Her Majesty. You've lost your liberty as a statutory creature. International covenants state no one shall be held in servitude. Natural laws teach us that human beings should not be held in servitude. This fundamental right applies for a human being. Constitution Act, its specific article only refers to the human being. So I couldn't go to the courts and say, well, listen, as a citizen, and it's been done before. And again, I'm not picking on anybody, but you know, if you're going to jab, you're going to get jabbed back here. People go on the internet and they bring up a judgment and say, oh, this guy went to court as a citizen and he was saying that it breaks his liberty and his right of association to have to pledge allegiance to the Queen. Well, of course he doesn't have that right. He can't even invoke that right. He's a statutory creature. His rights and freedoms have been limited and abridged already through the enactment, and he can't go to the court now as a statutory creature and say, well, listen, I'm being held in servitude. It makes absolutely no sense. You don't have that right to express that. You don't understand the law. That's why you created a file and went to court and tried to exercise that type of right. As a human being, yes. As a man or a woman, absolutely. You have the right to liberty. And if the enactment is placing you in servitude, then that breaks your natural right, your fundamental right that's protected in international law, then you could do it. But people are approaching the court as a statutory creature, claiming the rights that exist only for a man or a woman under their full legal capacity, and the judges and the courts are laughing. This right not to be held in servitude had to be transferred into domestic law. And since it's a foundational law, now this right is not like the right to vote. We're talking about here now the right not to be held in servitude. It's a right that every man or woman possesses. It's a natural right. You're born free. You have the capacity to remain free. You shouldn't be placed in servitude. It's a natural law. So it has to find its way into the foundational law of the nation. It has to find its way into the constitutional law of the nation. Not just a statutory power like the Bill of Rights. Yes, great, it's in the Bill of Rights. But again, that's a statutory power. Here, the obligation that's being brought forth through the international law is claiming this is a natural right, this is a human right that belongs to a man or a woman, and as a nation, you must bring it into your foundational law. You must bring it into your Constitution Act. And we, here in Canada, find it expressed in Article 7 of the Constitution Act. International Covenant on Civil and Political Rights, Article 5.1. Nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein in the covenant, or at their limitation to a greater extent than is provided for in the present covenant. When you looked at the court judgment, Supreme Court, Zinger versus the Queen, it says, thus ministers, agencies, and administrative tribunals would have to be able to justify their actions by pinpointing to specific legislative authority in the same way any citizen would have to be prepared to show that his or her acts were lawful. Now, it is a recognized principle of international customary law that a state may not invoke the provisions of its internal law as justification for failure to perform its international obligations. So they have the obligation, we see it in Article 2.2, saying these rights have to be transferred into domestic law. And here we're seeing in Article 5.1 where it's stating that they don't have any right to take any action aimed at the destruction of our rights and freedoms. And each and every one of us as individuals need to be aware of this and need to wake up to this fact, because these are all our individual rights and freedoms. And these obligations that I'm bringing forth in this video are obligations that you can hold the state party to, that you should be holding the state party to, because they're limiting and abridging your rights from the day you are born. And they're not supposed to point to domestic law enactments and regulations that rule and govern statutory creatures and statutory class of beings and say, well, look, here's the obligation, so you have to do it. No, I'm sorry, you're putting the cart before the horse. I don't have to be that statutory creature. I'm not going to play the role, enter into recognition or designation of that class of being, so that you can apply the color of law against me. This is a very powerful statement. It's teaching us few things. First and foremost, it is teaching us that no one, no government agent, no executive power, no sovereign, not even Her Majesty the Queen, can perform any act aimed at the destruction of our rights and freedoms that are recognized in the covenants. They can also offer no limitation upon these rights greater than what the covenant provides. This is basically teaching us that the international covenants are the ruling force, the ruling power, against how the state parties, including Canada, must create domestic law. There are provisions to limit certain rights and freedoms to a certain extent, but these limiting powers are expressed in the covenant themselves. The covenant expresses when and how any state party can limit rights and freedoms. So don't let yourself become deceived and think that, well, I have rights, but Canada can just take them away and limit them, and that's the end of the story. No. Article 24 of the Constitution Act of Canada is clear. Anyone whose rights and freedoms have been limited or abridged, according to this charter, you personally, you have the right to go before a court of law and say, listen, the executive powers of Canada, they're limiting and abridging my fundamental human rights and freedoms, my natural rights and freedoms, through a statutory power, whatever it may be. That's your right to do. If the state party is breaching the fundamental principles of justice as it pertains to a particular right, then you have the right to challenge it. The International Covenant teaches us very clearly that in a time of public emergency which threatens the life of a nation and the existence of which is officially proclaimed, the state parties, our countries, to the present covenant may take measures removing from their obligations under the present covenant to the extent strictly required by the emergency of the situation, provided that such measures are not inconsistent with their other obligations under international law and do not involve discrimination solely on the ground of race, color, sex, language, religion, or social origin. So in a time of emergency and public emergency, they have the right to limit and abridge certain fundamental rights and freedoms. Now, recently in America, Trump was voted in as the new American president, right? And there was a lot of worry going on that there was going to be protests and that maybe martial law was going to be declared. And if they declared martial law, then they were going to suspend the voting process. So yes, in international covenant, it allows a state party to suspend voting if necessary. If martial law came to be, if there was a war that started, if something happened in that way, they could suspend the right or the privilege to vote and then reinstate it after peace came to the land again. So there are certain rights and freedoms that they can limit and abridge. However, there are other rights and freedoms that they can never limit and abridge. And these rights and freedoms deal more specifically and more particularly with our natural rights and freedoms as men and women, our human rights and freedoms. So the International Covenant allows for limitations to be placed upon some of the rights and freedoms that are listed and enumerated in the covenants themselves in a time of emergency. This emergency could perhaps mean war, famine, or natural disaster. In a time of emergency, Canada can make derogation from certain obligations. Again, in a time of emergency, they can remove the right to vote. Listen, we're in an emergency. It's not time to vote. It's not time to hold elections. It's martial law now. End of story. The Covenant states that Canada does not lose its obligation, though, however, in a time of emergency, concerning the following fundamental human rights and freedoms. So this is showing you then there are certain fundamental rights and freedoms that are never to be limited or abridged, right? They are never to be removed, they are never to be limited, and they are never to be abridged, but we don't know them, and we don't understand that we have them, and we don't understand that we can stand upon them and exercise them. And one of them is, no one shall be held in servitude, in Article 8.2. And in Article 16 of the Covenant, it says, everyone shall have the right to recognition everywhere as a person before the law. Everyone, you as a human being, you have the right, not the obligation, but the right, the choice, to enter into recognition, to take designation as a statutory creature, as a class of being, as an artificial person before the law, to exercise civil rights. So if one of your fundamental human rights and freedoms, one of your natural rights is that you shall not be held in servitude, explain to me then how, through the statutory power, through the enactments that you saw in the beginning of this video, that they're taking you as an inhabitant and they're incorporating you without your consent into a body corporate, into a company, and then they are claiming that you owe them obligations, that you must serve their laws, that you must obey and respect their laws. Do you not see that they have limited and abridged your fundamental right and freedom? That they have limited and abridged a particular right that they're never even supposed to touch or be able to touch, even in a time of emergency. It is interesting to note that even during a time of emergency, the following natural fundamental human rights and freedoms remain in operation. Remain a recognized obligation upon the state party. They cannot force us into recognition as a person before the law. Neither can we be held in servitude to a political body or to a sovereign. Canada is aware of its obligations. When we look into domestic law, the enactments that have been given force of law, we find something designated the Emergency Act. When we read and look into this act, we find that these are laws that are to be in operation during the time of emergency. We find the following enumerated and listed in the Emergency Act. Emergencies Act Preamble. Whereas the safety and security of the individual, who's first? Political body, statutory creatures, or individual, human being, fundamental rights and freedoms. Whereas the safety and security of the individual, now, secondarily, the protection of the values of the body politic, and the preservation of the sovereignty, security, and territorial integrity of the state are fundamental obligations of the government. Absolutely. Fundamental law, natural law, fundamental rights and freedoms expressed in the Constitution, and part of that is the safety and security of the individual human being. And whereas the fulfillment of those obligations in Canada may be seriously threatened by a national emergency, and in order to ensure safety and security during such an emergency, the Governor and Council should be authorized, subject to the supervision of Parliament, to take special temporary measures that may not be appropriate in normal times. And whereas the Governor and Council, in taking such special temporary measures, would be subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights, and must have regard to the International Covenant on Civil and Political Rights, particularly with respect to those fundamental rights that are not to be limited or abridged, even in a national emergency. Now, therefore, Her Majesty, by and with the advice and consent of the Senate and House of Commons of Canada, enacts as follows. Notice that the Governor and Council, during taking such temporary measures, must have regard to the International Covenant on Civil and Political Rights, and more particularly to those rights that are not to be limited or abridged. Never. As a state party, Canada, they have these obligations. They must respect and ensure the rights and freedoms that were enumerated and listed in the covenants. There are certain rights and freedoms that can never be removed, that can never be limited or abridged. No one has the right to perform any act aimed at the destruction of our individual human rights and freedoms. Canada must provide a measure, whether through the Constitution Act when you're dealing with specific human rights and freedoms, or through statutory instruments when you're dealing with statutory creatures, to guarantee and fulfill these individual fundamental human rights and freedoms. This is a true and real position of Canada. This is the standing of Canada presently. We know that Her Majesty is the Sovereign of Canada and is the one who holds the executive authority and power of Canada. She transferred these powers to the executive government of Canada, and now they remain accountable to our individual human rights and freedoms. The Constitution Act of 1982 is very important to you and I as individuals. It is the expression of our human rights and fundamental freedoms. It is the mechanism that exists in Canada that allows us as individuals to exercise our rights despite what they are doing to us and our designations within their enactments and regulations. Now, Canada will apply the enactments and regulations against us only subject to the Charter. Remember MA versus Ryan? It says that the common law must develop in accordance with the Charter, and that the Charter is an expression of natural law, R versus Wagner, and that natural law is an expression of the international law, which is an expression of human rights and fundamental freedom. And Canada, their agents and their officers will try to apply their enactments and regulations against you. They will try to classify you as a statutory creature that owes a statutory obligation and a duty, only subject to the Charter. Only if you can prove that your charter rights are being infringed and denied by being forced to operate in this capacity will you be able to free yourself. In Meads versus Meads, it says the claim that a relationship between an individual and the state is always one of a contract is clearly incorrect. Aspects of that relationship may flow from mutual contract. For example, a person or a corporation may be hired by the government to perform a task such as road maintenance, but the state has the right to engage in unilateral action subject to the Charter. So they're saying the state will engage in action against you. They will try to classify you, designate you, render you a statutory creature, whatever it may be, and therefore owing duties and obligations to the statutory power, unless again you can prove that by the state doing this to you, they're violating a principle of justice. They're violating natural law. They're violating your fundamental human rights and freedoms, those that are specifically never to be limited or abridged. The International Covenant on Civil and Political Rights, Article 8.2, it says that no one shall be held in servitude. Now, if we just look at it logically, we can understand, well, that doesn't really work out because a citizen is definitely in servitude. The statutory creature that is designated citizen is under an oath of allegiance to either a political body or to a sovereign who rules the nation. Therefore, it is definitely in servitude. So the no one that they're talking about here, that should be no one. I don't know what that is. Not to. But, not to be held in servitude. The no one that comes before the rest of the sentence here. The no one refers only to the human being, only to the man or woman. Statutory creature is being held in servitude. Servitude to what? To the enactments themselves. If you're a driver, Highway Safety Code. If you're a citizen, Citizenship Enactment, under oath. So, no one, the human being, is not to be held in servitude. Now, the citizen is a statutory creature, and it is held in servitude. The human being is not to be held in servitude. Now, this is a natural right, and it must find its expression in the foundational law of the country, of the nation, of the corporation. It has to find its expression within constitutional law. That's the way it works. Got no choice. Here in Canada, we find it in Article 7, where it states that everyone, the man or the woman, has the right to life and liberty. And we know that liberty is the opposite, or goes against servitude. And remember, that court judgment says that the everyone, in Section 7 here, is specifically a man or a woman, because the rights expressed in here cannot be exercised by what? By a statutory creature. So if you go to them as citizen, statutory creature, you're already under servitude, under subjection. You can't call upon the right of liberty and say, well, the oath of allegiance, it harms me or it bothers me. That operation will never work. Why? Because this liberty here that's being spoken about, and that's preserved also in the Bill of Rights as a statutory power, is for a man or a woman under their full legal capacity. And if you don't understand that, and you go into the court as a plaintiff, or you go into the court under a civil suit seeking to exercise civil rights, guess what's going to happen to you? Remember at the beginning of this video, we talked about it. Statutory creatures, what do they operate? They don't operate fundamental rights and freedoms. They don't operate human rights and freedoms. They operate civil rights. And they are controlled by the enactments and the statutory powers. So think how funny that looks to the judicial system. And I'm not picking on anybody here, but a guy comes in, he says, listen, I came from another country and they made me take an oath of citizenship. And I think that bothers me. I want to be a citizen, but I don't want to have to be held in servitude or under an oath. You don't have a choice. Because what? Because you are a statutory creature. And you are given the rights and duties of the statutory power. Now if you went there, but you couldn't. But if you went there and you said, as a man under my full legal capacity, I believe, and I'm bringing forth this fact that by you forcing me to take recognition as a citizen, which is a statutory creature, a class of being, an artificial person in law, by you forcing me to take recognition as that citizen, you're breaching one of my fundamental human rights and freedoms that are never to be limited or abridged, not even in emergency. You are forcing me under subjection and in servitude to another person, not to an office, not to an imaginary figure, but your own law has declared that the Queen Elizabeth II, is a real person. And she's the head of Canada, and she's the executive powers of Canada, and she's living in law. And you are making me pledge allegiance and taking an oath of servitude to her in order that I give up my full legal capacity. And no, can't do that. Why? The International Covenant says that they can place limitation on certain rights and freedoms that you find in the covenant, but this one in particular, not to be held in servitude, they're never allowed to make a limitation or abridgment against that right. Even in a time of emergency, they're not allowed to limit or abridge that right. You're supposed to have the right to decide and to choose. But guess what? You never knew. Why? Because we were never taught. Why? Because they'd rather that all this information here be dug up, thrown in a pit, and covered over. And that you only operate from the position of a statutory creature in every aspect of your life. So when you're at home, you're a property owner, you're a home owner, you're incorporated into the municipality, and your property is being held, what? For the public good. And they're the administrators of it. That's where they get the power. They don't want you to know that when you're at home, you can stand under your full legal capacity and say, I'm not an officer of Canada, I'm not part of Canada, therefore the enactments, the statutory powers that you're seeking to enforce upon an officer of the corporate body does not apply to me. They only teach you how to operate in school through one capacity. That capacity is the statutory creature.
R. versus Wagner, 2015. The idea that there are certain fundamental unwritten principles that govern all members of society, including legislators, and which judges are expected to enforce, is not particularly new. The contemporary concept of unwritten constitutional principles can be seen as a modern reincarnation of the ancient doctrines of natural law. Now remember before when you watched that little video about the guy in the 1960s when they were talking about the Bill of Rights, and they said that these rights that we're expressing in the Bill of Rights, they're not new rights. They're unwritten principles that we are aware of, but because more and more people are coming into the country, we're afraid that the knowledge of these rights are going to be lost. So that's why we're creating the Bill of Rights. And here the judge is stating something similar. He's saying the contemporary concept of unwritten constitutional principles, so those rights that are unwritten, now can be seen as a modern reincarnation of the ancient doctrines of natural law. And what is natural law but natural rights? And a natural right is a right that is conceived of as part of natural law, and that is therefore thought to exist independently of rights created by the government or society, such as the right to life, liberty, and property. And again, going back to that little video there, the guy was mentioning, he said, we're not creating new rights. What we're doing is we're writing a statutory power that are going to express these rights that we already know are in operation in this corporate body called Canada, but they're unwritten. Only now they're going to be written down. And a natural right is an inalienable right. It's a right that cannot be transferred or surrendered. And it's an absolute right, a right that belongs to every human being. That's why when you go back and look into the International Covenant, and they talk about rights and freedoms that can be limited and abridged, there are certain rights and freedoms of a man or a woman that can never be limited or abridged. Why?
because they're not given to us by the government. They're inalienable, they can't be transferred or surrendered, and they belong to us. That's why the state parties are not supposed to have the power or the operations of law to place limitations or abridgments upon those specific rights. Why do they do it? Because the knowledge of them and the knowledge how to exercise them is dying, and few in between know this. Chief Justice goes on to note that these rules bind the legislative, executive, and judicial branches. The debate is not so much about whether such norms exist, but as to what those norms are in relation to any given case where a litigant calls on such norms to aid. So again, a guy goes into court as a statutory creature, as a citizen. He goes before the court, which is now a statutory court, and he says, I don't agree with the oath of allegiance to the Queen. The court says, why? Well, because, why should I have to pledge an allegiance and an oath to the Queen and be in subject and servitude to her as a citizen? Well, because you can only exercise rights and powers and duties and obligations that are brought forth in a statutory power in the enactment, and that's what the enactment declares. And because you're a statutory creature before the court, you can't call on Article 7 of the Constitution Act. You can't call on the rights and freedoms that are only exercisable by a man or a woman in their full legal capacity because you came to the court as a citizen complaining. Finally, at the developing fringes of the new natural law, which goes by the name of human rights, are other assertions. It rests on the proposition that there is a distinction between rules and the law. Rules and the rule system can be good, but they can also be evil. And I believe he's stating this and writing this here because he's talking to the judicial system also right now. And he's saying to them, all these rules and the rule system that apply to statutory creatures, that apply to classes of persons, they can be good because they restrict and limit actions of individuals who need to be restricted and limited. However, they can also be evil if what? If the one who's being ruled by these rule systems are trying to exercise their fundamental rights and freedoms, their charter rights and freedoms, but you're continuing to class them and keep them under a statutory power. Thus, as important as these principles may be, and as essential as it may be that in difficult cases, the judge must stand against the winds and the rains to uphold them. The judges are expected, they have the obligation to stand against the political power, to stand against the statutory power, and say, as a man or a woman, if you can prove and show to me that there's been a limitation and abridgment of your charter right, of your natural right, of your human right and fundamental freedoms, I have the responsibility to stand against the Crown, statutory powers, political powers, and protect your rights as an individual. And these unwritten principles of our natural rights and freedoms, of fundamental rights and freedoms, have now been largely replicated in the text of the Constitution, with Section 7 of Canada's Charter of Rights and Freedoms as being a prime example. The writers of the Constitution reflects many, many influences, including the drafters' awareness of natural law. So the judge is saying here, when they wrote up the Constitution Act of 1982, the ones who wrote that Constitution, they were aware of natural law. They were aware of fundamental human rights and freedoms, and they protected these fundamental rights and freedoms within the Constitution, within certain articles of the Constitution Act. And Article 7 is being one example. Well, why did they do that? Because again, natural law, fundamental human rights and freedoms, it's foundational law to a country. It's foundational law to a nation. And this must be included in their foundational law. It must be included in their supreme law. It must be included in their Constitution Act. And we also see it secondary being witnessed of in the International Covenant, where it says in Article 2.2, these rights must be expressed within a constitutional process. And we know those rights are the rights of the men and the women. R versus Rio Regional Police Services, Chief of Police. The courts, too, must conform to the rule of law. The rule of law is the very foundation of the Charter. It stands to reason, then, that the courts are duty-bound to apply the Charter. The rule of law is that you and I have natural rights and freedoms that are not to be limited or abridged. This rule is a superior rule concerning law. Everything else is subjected to this rule. That's why these rights are protected within the Constitution of the countries. The only problem is that you were never told of this rule or this right that is in operation in Canada. You have been made aware of many rules, but not this most important one. Rule of law, natural rights and freedoms, superior to all, preclusive to arbitrary interference, never a situation that justifies limiting these rights. You have inalienable rights, and they are not to be limited. The government does it anyways because they do it based upon you not knowing the rules. The Constitution is the ground law, the fundamental law of Canada. Canada versus Sam Levey and Associés. First, and most importantly, the Constitution is, under Section 52 of the Constitution Act, the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. So we hear it often, oh, the Constitution Act of Canada is the supreme law of Canada. And then we say, if any law goes against the supreme law of Canada, then it's of no force or effect against me. But we don't really understand what we're declaring. When we're saying that the Constitution is the supreme law of Canada, yes, it is. It's the foundational law of Canada. And because it is the foundational law of Canada, by default, it must express, it must contain, it must protect our fundamental human rights and freedoms, which it does. And that's why it's the supreme law of Canada. Because if they try to take us out of that designation, away from our fundamental rights and freedoms, and force us into a classification as a statutory creature that owes obligations to a statutory power, then that law, that operation of law, that force that you're using against me, is of no force or effect, especially if you're trying to limit and abridge one of my natural rights and freedoms that can be never limited or abridged, even in a time of emergency. Building off of R. versus Wagner, where he's stating that Section 7 of the Constitution reflects the drafter's awareness of our natural law, our fundamental rights and freedoms as human beings. Gosselin versus the Quebec Attorney General, it is clear that Section 7 surely protects the right not to be deprived of one's life, liberty, and security of the person when that is done in breach of the principles of fundamental justice. Let me ask you and make you think here a little bit. If we see that within natural law, within human rights and fundamental freedoms, there are certain rights and freedoms that are never to be limited or abridged. Even during a time of emergency, there is never to be a limitation or abridgment applied against these rights. Then wouldn't that by deduction teach us that there is not a principle of fundamental justice that can be applied to these rights in order to limit and abridge us? That our state parties cannot bring forth domestic law and place a limitation and abridgment upon these specific rights because it's not a principle of fundamental justice, because you never had the power to do so from the beginning, even though you may have done so. Clearly, positive rights are not at odds with the purpose of the Charter. Indeed, the Charter compels the state to act positively to ensure the protection of a significant number of rights. Positive rights, natural rights, fundamental human rights and freedoms are not an exception to the usual application of a Charter, but an inherent part of its structure. The Charter as a whole can be said to have positive purpose, in at least some of its constituents do. State Communications Incorporated versus Davidson. Now this is a little bit of an older one, but it's showing us the power that's transpiring here. The reference in Section 32 to the Charter in there are human rights and fundamental freedoms, natural rights, that are never to be limited or abridged. End of story. Never. Even during a time of war. Now, Wagner and that other case, Gauthier versus Quebec, it says that the expression of these rights, these natural rights, these fundamental human rights and freedoms, have been included in Article 7. And then when you look to Article 7, it states this, and I'm paraphrasing. You have these rights, the right to life, liberty, and security of the person, and you also have another right. And that right is the right not to be deprived of these rights except through a principle of fundamental justice. Now, we already know that the drafters of the Constitution were being a little bit dishonest, and I'm being nice here, because they used the word everyone to bring forth the designation of the man or the woman, the human being. rather than just state it clearly and say men and women, like they did in the Russian Constitution, have the right to life, liberty, and security of the person, they hid it by saying everyone and make you go down the rabbit hole and the maze to figure out what are they talking about here. So, but you have these rights. Now, the rest of the phrase goes on to say this: the right not to be deprived. Okay, that's another right. So there's 4 rights here that are being exercised: life, liberty, security of the person, and now the right not to be deprived of these rights, except through the principle of fundamental justice. Okay, again, Article 7 expresses natural law, fundamental human rights and freedoms. Now, by default, these fundamental human rights and freedoms are not to be limited or abridged. Why? Because covenant says so. Because human rights said so.